Hey, how's it going? We're going to take a look at the limitation imposed on peace officers. The limitation is provided by the state legislature, and we're going to take a look in the California Penal Code. Now, most people are aware that peace officers, police officers, have been authorized to apply the state's police power to conduct that rises to the level of a crime. And what we're going to look at is another kind of a crime identified by the term public offense. A public offense and a crime is the same thing. If you're convicted of a crime or a public offense, the possibility exists you might wind up going to jail. So there's a jail sanction and there's a fine. But when it comes to vehicle code infractions, there is no jail sanction. They just want money. So if you're convicted of let's say a low tire, a burned out taillight, speeding, not wearing a seatbelt, they just want your money. You're not going to go to jail for any of that stuff. However, as we saw before in one of the other videos, when a peace officer pulls somebody over for an alleged violation of the vehicle code, it's called an arrest. And there's procedures on arrests in the vehicle code provided by the state legislature. These procedures apply to peace officers. They don't apply to me. They don't apply to you. They apply to peace officers. And we've been informed that when you're subjected to a police contact for an alleged violation of the vehicle code, you're arrested. And that the cop is the arresting officer. And that you're the arrestee. And that you're in custody. And if you want to be released from custody, you need to sign a promise to appear. And when you do that, the arresting officer is instructed to release you forthwith. So, this is where we find some interesting information about the limitation imposed on the peace officer and what they get to do. And what they get to do is they get to, this happens to be section 830.1, and at this section it tells us what peace officers get to do. Number 3 is interesting. They get to apply the state's police power to any public offense committed or where there's probable cause to believe one has been committed in his presence. Now what we're concerned with is warrantless arrests. And this is a limitation and authorization found here at 836 having to do with the peace officer's power. So whenever he has reasonable cause to believe that the person to be arrested has committed a public offense in his presence, he gets to make a warrantless arrest. It's valid. He's following the rules. Now most people are aware that if you're accused of a vehicle code infraction here in California and you decide to have your day in court, you're not going to get a jury trial. But I would think everybody is aware of the fact that if you're accused of a crime under our justice system in this country, you're entitled to a jury trial. You're also entitled to a public defender paid for at the public's expense. And on conviction, you may wind up going to jail because there's a fine and a jail sanction. However, this is an interesting section in the Penal Code. It's section 689. And what we're informed here is that you can only be convicted of a public offense based on a verdict by a jury. So if you're accused of a public offense, you get a jury trial. And we're also informed in this same book that the peace officer is limited to in their application of the state's police power to public offenses. So, a public offense must be a crime. However, when you go to traffic court for an infraction, you don't get a jury. Upon conviction for a traffic infraction, a vehicle code infraction, they just want your money. There appears to be a bit of a problem here. The officer is authorized to make a warrantless arrest for a public offense committed in his presence. However, when you go to court for a vehicle code infraction, you don't get a jury trial. And we're informed in the penal code that only a jury can convict for a public offense. A vehicle code infraction cannot be a public offense. As a matter of fact, we've been told by the Court of Appeals that it's not a public offense. We've been told that it's not a crime. We've been told it's not a crime by the Judicial Council of the State of California. The Judicial Council is made up of judges, and the Judicial Council authorizes all the forms that are used in the courts of California. Even the Attorney General of the State of California has informed us that vehicle code infractions are not crimes. So what we have is a peace officer, a police officer, applying the state's police power to conduct that doesn't rise to the level of a crime. And they've been getting away with this for 40 years. Because 40 years ago was when the infraction was codified into law, 1969. That's when the infraction was codified into law. Prior to 1969, there were only felonies and misdemeanors. And if you're accused of a felony or a misdemeanor, you're entitled to a jury trial, public defender paid for a public expense, and you might wind up going to jail if you're convicted. 1969 rolls around, the vehicle code infraction is codified into law. However, it was sponsored by the Judicial Council, endorsed by the Judicial Council, and they identified the vehicle code infraction as non-criminal. So we have police officers applying the state's police power to non-criminal conduct. The only way they're getting away with this is because we don't know about it, and we're not raising the issue when we're supposed to raise the issue, when it would benefit us the most, at trial.